And I think the greatest weight was placed on the relative burdens of the parties. Tashikari was going to be completely landlocked if he did not have access to this driveway. The property would be rendered virtually valueless. In comparison, the neighbor who was complaining about this use had never used it, and indeed his property didn't well connect to the driveway because he had built a wall and some privacy, put in some privacy hedges and so forth. So the court applied that test and affirmed the lower court. And I think that the main point here is in Tashikari is really looking at the equities. And then if there was a procedural point raised by the appellant on appeal, the complaining landowner, and that was can you obtain an equitable easement affirmatively, or can it only be raised on a defensive basis? I had never heard that argument advanced before. I had always, my own practice, believed that you could obtain an equitable easement affirmatively as the plaintiff by seeking quiet title and declaratory relief. But this landowner raised an interesting argument, and it's developed in the appellate decision, and it goes into a primary rights theory, and ultimately the appellate court just flatly disagreed and said what was happening there was the landowner was taking a set of cases where just by happenstance the fact pattern had been that the party seeking to quiet title was the one who was complaining, and the party seeking the equitable easement was a defendant. It's just the way it arose in those cases, and there was no set requirement, absolute requirement, that you can only obtain an equitable easement from a defensive standpoint.